A Southern California restaurant chain is cited for more than $4.5 million by the California Labor Commissioner. And get this, it's not even for their own employees. The Labor Commissioner held the Cheesecake Factory restaurants liable under Labor Code Section 2810.3. What can employers learn from this? First, employers need to understand that any subcontractor work that they have come into their establishment to do work can create liability for them. So they need to ensure that those employees that they're contracting to come in are paid properly. And two, employers need to make sure that those employees are receiving all their meal and rest breaks and have an avenue to complain. So employers need to understand that just because they subcontract out work to other parties, they're still liable for those wage and hour violations, and they need to ensure that those employees are being paid properly and that the companies they're contracting out the work are reputable and complying with all wage and hour laws.